Good evening. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. Who's in the house on a Thursday? Melissa in Great Neck Yehud in South Carolina, Billum in Missouri, Sharon in New Jersey, Paul in the Great Northwest, Shandor in the Bronx, Bell in Texas, Lucy in Minnesota, Joe in the Inland Empire, Jonathan in LA, Ella's with us, Aoife in Florida, Marjorie in Georgia. Welcome, everybody. Another short page. So short, we're going to do a double. Just to continue getting a little bit ahead, which will stand us well when we take the trip to deliver our kids to college. And we're going to miss the day next week for Tisha B'Av. Our dafs today are pages 49 and 50 here in Tractate Bava Basra, the 23rd volume of the Talmud. Picking this up halfway down, page 49a, continuing our discussion of Mishna number 4 here in chapter 3 of Tractate Bava Basra, the 23rd volume of the Talmud. The Mishnah taught that a man does not have the ability to establish the presumption of ownership with regard to his wife's property, and a wife does not have the ability to establish the presumption of ownership with regard to her husband's property. Why? Because they are obviously expected to have the full use of each other's property while they're married. So the fact that one of them is making use of the property that belongs to the other, and it is possible for property to belong to her and not to him, though while they are married, he would have the right to use her property to benefit from the produce of that property. But the fact that he's there on her property and using it and selling the produce, even for more than 3 years, does not establish him as a presumptive owner of that property, because we understand they're husband and wife. He has reasons to use her property other than the fact that he would be the outright owner of it. So the Gemara asks, isn't this obvious that we don't establish a presumption of ownership between a husband and wife over the property of one or the other? Since he has the right to enjoy the profits of her property while they are married, it is known that he is only enjoying the profits and that he has no claim to the field itself. On what grounds, then, would he establish the presumption of ownership? Since there are no grounds, why does it need to be stated that he has no presumption of ownership? And the Gemara responds, no, it is not obvious. And it is necessary to teach this halacha, this law, in a case where the husband wrote to his wife, I do not have any legal dealings or involvement with your property, i.e., he forfeits his right to enjoy the profits of this property that she brought into the marriage. Since he forfeited all rights to enjoy that property, can he later start using it and establish the presumption of ownership? In other words, he had no right to use her property. If he starts using the property, it's because he had to purchase those rights. He purchased the field from her. So then maybe he doesn't have the deed, do it. Maybe it was done in an oral agreement. But if it's well known in the community that he gave up his right to use her property, and then later he was using her property, and then he says, and the reason I started using it is because she sold it to me, and this goes on for 3 years without her protesting, so then maybe he could establish a presumption of ownership. So it was therefore necessary, since that is a possible, you could have thought that that might happen, and then therefore he could have a presumption of ownership. It is for that reason that you might have thought that the Mishnah comes and says, no, a husband can never get a presumption of ownership over property that belonged to his wife. He could purchase it from her, but he would have to prove it. He would have to bring proof. He would have to bring the deed. He would have to bring witnesses, etc. He will never get a presumption of ownership. So absent such proof, he will not be able to take ownership of that land. And now the Gemara asks, well, wait a minute. Even according to that thinking, that if he gave up his rights and then he purchased the land, that he could acquire presumption of ownership, even if you held like that, you would need that his writing of I hereby give up all rights to your property would be a valid writing. And the Gemara asks, And if he wrote this to her, what of it? And isn't it taught in a baraisa? One who says to another, I do not have any legal dealings or involvement concerning this field, or I have no dealings with it, or my hands are removed from it. This person has said nothing. That is to say, these statements have no legal significance. Now, the scholars of the school of Rabbi Yanai said with regard to this, the Mishna states its ruling with regard to one who writes this formulation to her, a husband to a wife, while they are still only betrothed. See, after they're married, if he says, I have no legal dealings with your land, he hasn't said anything because he already acquired this right to use her property once they got married. And the fact that he says, I have no legal dealings with it, doesn't actually shed his rights. He doesn't give up his rights by making that statement. However, if he makes such a statement while they're betrothed and before they're actually married, then he will thereby cause that when they enter the marriage, he will not get a right to use her property because he gave that up essentially while the contract was still being negotiated, as it were. Right? So if he writes this formulation to her while she is still only betrothed, before he had any rights to her property, therefore he is able to prevent his rights from taking effect after the marriage. And this ability to give up rights that you would have otherwise gotten in the future, right? He says this before they're married, and he's saying, when we get married, I will not take the right to use your property that you brought to the benefit of produce from your field that you bring into the marriage. He can give that up before they actually married. And this is in accordance with the statement of Rav Kahana. As Rav Kahana says, and now we're on page 49b, with regard to an inheritance that comes to a person from another place, i.e., an inheritance one will receive in the future. Right? In other words, if somebody, you could say that somebody has a rich relative who has said, when I die, you'll get my fortune, and the guy hasn't died yet, right? So this is a person who stands to receive an inheritance, but he hasn't received it yet. So right now, he owns nothing. But he has a reasonable expectation that he will inherit something. So what about it? With regard to an inheritance that comes to a person from another place, i.e. an inheritance that one will receive in the future, a person can make a condition about it from the outset that he will not inherit it, since one can waive his future rights to property that is not currently his. And this ruling is in accordance with the opinion of Rava. As Rava said with regard to anyone who says, I do not want to avail myself of an ordinance of the sages, such as this one that was instituted for my benefit, one listens to him, right? Somebody who stands to inherit, or somebody who will be able to make use of an ordinance that was instituted for his benefit. He can say, I do not want that benefit. I will not take that benefit when it comes my way. And then we listen to him. Now the Gemara asks, what is meant by such as this one, when we say some decree of the sages that was instituted for your benefit and you decide you don't want to avail yourself of that benefit? So what's an example of that? Asks the Gemara. And the Gemara explains that Rav is referring to that statement of Rav Huna, who said that Rav says, as Rav Huna says that Rav says, a woman can say to her husband, I will not be sustained by you, and in turn, I will not work. In other words, you will not keep my earnings. And the Rav Steinsaltz explains that the sages instituted that a husband must provide sustenance for his wife. And in exchange for agreeing to sustain her all the days of their lives together, he is entitled to her wages. But if she works and earns wages, he receives the wages because he has already agreed to shelter her, clothe her, feed her, etc. for her whole life. Now, since this was instituted for the benefit of wives, the wife is able to opt out of this arrangement. She can say, no, you don't have to sustain me, and whatever I earn through my independent work, I will keep it. Right? This would obviously make sense for a wife who's the bigger earner in the couple. She says, you know what I earn is mine, you don't have to sustain me. And she's going to do better that way. so she does not have to avail herself of this decree that was instituted for the benefit of wives. It is in such a circumstance that the Mishna rules that even if he relinquished his rights, he does not establish the presumption of ownership by enjoying the profits, right? So he gives up such rights, but even so, if he then comes to use the land that he gave up the right to use because he bought it from her, well, he better be prepared to prove that he bought it from her, because a presumption of ownership just from using the land for an extended amount of time, even after he, publicly and in front of witnesses gave up such a right, still he will not get that presumption of ownership. New subject. The Mishnah taught that a husband does not establish the presumption of ownership of his wife's field by enjoying its profits. Now the Gemara suggests by inference, the husband has the ability to bring proof that he purchased the field from his wife or received it as a gift from her, and consequently be regarded as the owner of the field, right? He can't have a presumption of ownership just by using it, but he can buy it from her and he can bring proof, and then it is his field. Now the Gemara asks, why is this proof decisive? Let her say, I did it, i.e. I gave or sold the field to my husband only to please my husband, but I did not mean it. So this is interesting. It's not saying coercion. It's not that the husband forced his wife to sell the field to him or to gift the field to him, but the nature of a husband and wife relationship, right? No two people are closer than a husband and wife living together. So maybe she can claim that, well, he really wanted it, and he said he wanted it, and so I said okay, but I didn't really understand what my legal rights were, and I just said okay to please him, but I didn't mean to relinquish a field that belonged to my family, that I brought into this marriage, and that I expected to take out of the marriage with me if we divorced, or if if I was widowed from him. I didn't expect to lose that land. I only said yes to please him. So do we listen to her or not? So the Gemara quotes a source for the idea that we do listen to her claim. Didn't we learn in a Mishna, Tractate Gittin 55b, that if one first purchased land from the husband and afterward he returned and purchased it from the wife, i.e. he purchased her rights to this land after the death of her husband, or in the event of their divorce, as stipulated in the marriage contract, then this transaction is void. So interesting, right? So the husband says, I'll sell you this field to his neighbor. And the neighbor says, great, I want that field. So he buys from the husband. But it turns out that the field actually belongs to the wife. The husband has the rights to use it. So now the neighbor has the right to use the field, to farm the field, to harvest the produce of that field and sell it. But if the couple divorces, or if the husband dies, well then that usage right terminates and the field goes back to the wife. Now when the neighbor learns that what he bought was just a usage right and not the field itself, he says, no, that's not what I wanted. I want the field forever for my family. So I'm going to go back now and buy the underlying rights from the wife. He already bought the usage rights from the husband. Now he's going to buy the underlying ownership rights from the wife. And in that situation, even though he paid the husband and then he paid the wife, we say the transaction is void. You can't do this. Why? Because apparently the wife said, I did it only to please my husband, but I didn't mean it, right? In that situation, she can say that, yeah, she agreed to the sale only to please her husband, but she didn't really want to give away this inheritance of hers that belongs to her and, presumably her family. Like, she brought it into the marriage and she expects to take it out of the marriage. So if in that situation where a purchase and sale to a third party ends up being void because she can claim that she didn't mean to sell it, she only agreed to please her husband, then why can't we use the same argument when the husband himself is trying to buy the field, for himself, so that he doesn't just have the usage of it, but he has the complete ownership of it? Why can't we make the same argument on her behalf? And the Gemara answers, but wasn't it stated with regard to that Mishnah about selling to a third party that Rabba bar Rav Huna says the law that a woman can claim that she acted only in order to please her husband is not stated with regard to all of her property, but is necessary only with regard to those three types of fields that have special status. 1, a field about which he wrote to her in her marriage contract that it would serve as payment of her marriage contract. Right? So when they got married and he gave her a ketubah, he said this particular field right here is a guarantee that if I die or if I divorce you, you're going to get what we agreed. Let's say the ketubah payment is going to be 1,000 dinars. He's not necessarily going to have 1,000 dinars in cash at the time that he dies and his estate needs to pay this, or at the time that he divorces her. But he already designated a field to serve as the guarantee for that 1,000 dinar payment. So that kind of a field cannot be sold. And even if she agrees to sell it, she can claim, I only said yes to please him. Now we're on page 50a. Number 2, one that he specified to her as payment for her marriage contract, even though it was not stipulated explicitly in the contract. Same idea, that field is going to serve as a guarantee for my ketubah payment to you. That field was not specified in the ketubah itself, but he said in front of witnesses, this field will act as the guarantee for the ketubah payment. So that one also, they can't sell it. And if she agrees to that sale, she can later claim, no, I didn't mean it. I only said it to please him. And number 3, in a case where she brought a field into the marriage with an appraisal from her own property that she owned prior to the marriage, which took on the status of guaranteed property, meaning that she will receive it if her husband dies or divorces her. In other words, she didn't just bring a field into the marriage, she had it appraised, which would serve to put it in the category of guaranteed property, right? Now we know that this field, what it's worth, and if you ever die, your estate has to give me that field back. If you ever divorce me, I take that field back because we specified the field for that purpose. Now, the Gemara clarifies. Well, to exclude what type of property did Rabbah specify these 3 types of fields? Like, what else is left that would be hers that she could, agree to sell, and the sale would be a valid sale? What is that category? So if we say that he intends to exclude the rest, so what did Rabbah intend to exclude? Did he intend to exclude the rest of the husband's property that is secured to pay her marriage contract? Well, it is all the more so the case that he will bear her enmity if she does not agree to the sale, as he will say to her, you have placed your eyes on divorce or on my death, i.e. you will not allow me to sell my property because you are expecting and planning for my death or our divorce. Therefore, because so he wouldn't feel that way, she might say yes just to please him, but she would only be saying yes to please him, not because she has a sincere wish to allow that to be sold. So rather, Rabbah specified these 3 types of property in order to exclude usufruct property, i.e. property that belongs to the wife and remains in her possession while the husband has the right to enjoy the profits, but it was not appraised, right, to act as guaranteed property, in which case, if the wife consents to the sale, it is valid. Is it? The Gemara asks, but doesn't a Maimar say that if there was a man or a woman, i.e. a husband or a wife, who sold the wife's usufruct property, they did not accomplish anything, as the sale does not take effect? So what are you talking about, usufruct property? They can't even sell that, period, let alone with her consent. And the Gemara answers, when the statement of a Maimar was stated, it was to say that neither the husband nor the wife can sell the property unilaterally. Where he sold the property and then died, she can come and remove it from the buyer. Alternatively, in a case where she sold it and then she died, he can come and remove it from anyone who then got it. And this is due to a rabbinic ordinance and in accordance with the statement of Rabbi Yosef bar Chanina. As Rabbi Yosef bar Chanina says, when the Sanhedrin convened in Usha, they instituted that in the case of a woman who sold her usufruct property in her husband's lifetime, and then she died, the husband repossesses it from the buyers. Now, this is because, with regard to the normal case of usufruct property, she brought it into the marriage, he can use it. They didn't do this appraisal, which would mean it was really set aside for her. Then what that means is he can use it while they're married. If he dies, she gets it back. It doesn't go to his heirs. If he divorces her, she gets it back. But if she dies, he inherits that property. So that's the difference between property she brings into the marriage as usufruct property, distinguished from property she brings into the marriage, which can be used as usufruct property, but which she had appraised so that it would remain part of her family even if she dies. But where the two of them sold it to someone, or if she sold it to her husband, then the sale is valid, right? In the absence of that appraisal that she did before they got married, if she brought it in for it to be usufruct property, then the two of them can jointly decide to sell such property, because maybe they want to start a new business, and farming hasn't been going good for them, and the two of them as a team would like to sell that land and get the money and start something new. Yes, they can do that. Now, since they can do that together, they can also jointly agree that for that kind of property, she could sell it to him, and it becomes fully the husband's. So the inference that the Gemara drew from the Mishna, that if the husband produces evidence that his wife sold usufruct property to him, then he is regarded as the owner, is relevant when she sells her usufruct property, unappraised usufruct property, to him. That's a valid sale. If he brings the proof, the witnesses, the deed, etc., he can establish that land as his own, right? But he will never have a presumption of ownership. He has to bring the proof. And if you wish, say instead that a Meimar said his statement in accordance with the opinion of Rabbi Elazar, who holds that one can sell property only if he possesses the item itself and also has the right to enjoy its profit. So this is a more general statement about selling property. Makes sense, right? If you, for example, they're going to give an example, but the idea is in order to validly sell a piece of property that you own, you have to have both the underlying ownership and the right to use it, right? And if you don't have both of those things, then if you try to sell that property, the sale is not a valid sale. And now the Gemara will explain. And this is as it is taught in a Baraisa. In the case of one who sells his Canaanite slave, this is a Canaanite slave as opposed to a Hebrew slave, because Hebrew slaves were not owned in perpetuity. Canaanite slaves were. So thank God slavery is gone from slavery is gone from the Jewish world, and it has been gone for thousands of years. Tragically, slavery still exists in the world. But in terms of the laws, we still discuss the laws. So, in ancient times, when slavery was legal, in the case of one who sells his Canaanite slave to another and contracted with him that the sale is on the condition that the slave will serve the seller for 30 days before he is transferred to the buyer. So the outcome of this sale is that during those 30 days, the first master enjoys the use of the slave, and the buyer is the owner of the slave. Now, why is this relevant here? It's a very interesting question that they're going to ask. Who is the actual owner? Is the owner the purchaser, right? The purchaser purchased the slave. He has legal title to the slave. But in that purchase agreement, they agreed that for the first 30 days, the old owner would continue to have the use of the slave. Now, what they're going to say is the murder law was different for the owner of a slave versus any other murder in the world, right? So if you commit murder, that's a capital offense, and you're going to be executed for that if you did it in front of witnesses, if you were warned that committing murder is a death penalty offense. I think for murder, you may not even need the warning. But if you commit murder in front of witnesses, then you're liable to be executed by the court. The Torah also specifies, however, and you can see how barbaric slavery was, that because it was common for masters to beat their slaves, that now and then, they would beat them very hard. Now, if you beat your slave so hard that the slave died from the beating, and it was obvious that the cause of the death was the beating, then even the master of the slave is liable for murder, is a death penalty offense, and can be executed for that. But if the master of a slave beat the slave and the slave survived for a few days and then later died, then it's not so clear that the slave died from the beating. And in that case, the owner is not subject to the death penalty. The question they're asking here is, if somebody bought the slave from the owner, so now the purchaser is the new owner, but the old owner, the prior owner, still has the use of the slave for 30 days, and during that 30 days, he beats the slave, and the slave doesn't die right away, but a few days later does. So does that exemption from the murder law apply to this former owner who is no longer the owner? He legally has the use of the slave for those 30 days, but he's not the actual owner. So what is his relationship to the slave during those 30 days? Is he like the owner for the purposes of this murder exemption? Or is he like any other person? And if they can show that it was, his beating that ultimately caused the death, then he is liable to the death penalty. So let's see. So the Baraisa states 4 opinions about that case. Rabbi Meir says that during those 30 days, only the first master, the prior owner, is included in the law of a day or 2 days. This is Exodus 21:21, that exception for the owner of a slave. And Rabbi Meir holds that in this case, the first master is included in this exemption because the slave is under his authority as he enjoys the use of the slave. But the second master, if he were the one to do the beating, he would not be included in the exception of a day or 2 days because the slave is not under his authority. So even though he's the actual owner, if he's the one who beat the slave and the slave died a few days later, he would be liable to the death penalty because the slave was not yet under his authority. So Rabbi Meir's reasoning is that he holds that ownership of the rights to use an item and the profits that it engenders is like ownership of the item itself. The status of the first master as the owner negates the possibility that the second master would be regarded as the owner with regard to this law, and he would not be included in the exemption. Now, Rabbi Yehuda says that the second master is included in the law of that exemption because the slave is his money, i.e. his property. Right? The way the Torah speaks about the slave is that, this guy has greater leeway to beat the slave and to get away with it because the slave is his property. That's the nature of slavery. So says Rabbi Yehuda, the second master, he is the owner. So if he beats the slave and dies, and the slave dies a few days later, that second master does benefit from that exemption. And Rabbi Yehuda's reasoning is that he holds that ownership of the rights to use an item and the profits that it engenders is not like ownership of the item itself, meaning that the first master, who still has the use of the slave, is not considered the owner. Rather, the owner is the owner of the underlying rights. Now, Rabbi Yosei, this is the third opinion, says, now on page 50b, that both of them are included in the law of a day or 2 days. This first master is included because the slave is under his authority, and that second master is included because the slave is his money. In other words, they both have a right to the slave, one as the owner, one as the one with authority over the slave during these 30 days, and so they both benefit from the exemption. And Rabbi Yosei reasons that the reason they both benefit from the exemption is that he is uncertain of who the owner is. We're not sure whether the new owner is the actual owner, whether the old owner who still has authority is still considered the owner. It's suffix, doubt. We're not sure who. He's not sure whether the use of an item and the right to the benefit of the item is like ownership or not. And because Rabbi Yosei is uncertain, well, this is a case of capital law, where if we find the guy who administered the beating guilty, then he's going to be executed. But we don't execute a defendant where there's any uncertainty at all in the law. So because there's uncertainty and it's a capital case, we can't execute. So we do extend that benefit of the law to both of them, so that they would not be executed because of that uncertainty. Now, that the fourth opinion is Rabbi Elazar. Rabbi Elazar says that both of them are excluded from that law. Right? Rabbi Elazar is going to be much more stringent, sort of acting as an advocate on behalf of the victim of the beating, the slave, and he says that neither the old master who has authority for 30 days nor the new master who has the underlying rights but doesn't have that authority, neither one of them can benefit from the exemption listed in the Torah. The second master is not included because the slave is not under his authority. The first master is not included because the slave is not his money. It's not his property anymore. So Rabbi Elazar holds that one must both own the slave himself and enjoy the use of the slave to be included in that exemption. I'm almost done. Questions or comments, please get them in now. So the Gemara explains how Ameimar's statement is in accordance with the opinion of Rabbi Elazar. And Rava says, what is the reason for the opinion of Rabbi Elazar? Well, the verse states, notwithstanding, right, the verse that exempts the master from being liable to execution, the verse at Exodus 21:21 says, notwithstanding, if he, the slave, continue to live a day or 2 days, the master shall not be punished, for the slave is his money, meaning his property. And Rabbi Elazar understands this to be referring to a slave that is his money, a slave that is unique to him. So this exemption does not apply to one who does not have total ownership of the slave. Rabbi Elazar holds that one is considered to own an item only if he owns the item itself and also enjoys the use of it. And this is the source of Ameimar's statement that neither the husband nor the wife can sell usufruct property. The husband cannot sell it because he does not own it, and the wife cannot sell it because only the husband has the right to enjoy the profits. We'll leave off there, and with God's help, we'll pick it up tomorrow at the normal Friday time of noon Pacific. Okay, a couple of questions from Bell. How does the wife prove that she kind of assented to the sale, but that it wasn't a real consent? I think what they're saying here is if the situation is one where she can make that claim, she doesn't have to prove it. She just makes the claim, right? She doesn't have to prove it. In other words, it's a kind of situation where we don't like the fact that the husband sold it because he's in a position, again, it's not coercive, but, he has a lot of authority in his own home. She's just, she has to live with this guy. Maybe he does all of, especially in the ancient world, right? He did all of the financial legal dealings of the household. So did she really know what she was consenting to? So she doesn't have to prove it. If it's a situation where she could make that claim, then her claim is accepted if she makes it. Bell also says, what if not a beating? But this slave, what if not a beating? But this okay. Bell is saying, let's talk about a different situation. Not whether the master is, can benefit from the exemption of a master who beats his slave and the slave doesn't die right away and then only dies after a few days, that he would not be liable for the death penalty. What about a different situation? So Bell is posing the following hypothetical, right? The slave is a craftsman. The slave is a craftsman with a very valuable craft, right? Let's say he's a diamond cutter. So the old master is selling this very valuable slave, right, who's a diamond cutter, and he sells him, to a new owner. And he says, I'm going to keep the slave for 30 days, and then you can have him at the end of the 30 days. So what about if he manufactures, or he cuts a diamond, or, maybe he's a sculptor and he creates a beautiful and valuable sculpture during those 30 days? Who owns the craft? Who owns the creation created by the slave during that 30-day period? And what if that creation had been commenced but not completed? Bell, you are really thinking like a Talmudist. Well done. I think in that case, when you say that, but I'm going to use him for 30 days, and then you can have him, I think that's like usufruct property. I think what he's saying is, and I get the benefit of his work for these 30 days. But what if he commences a project and doesn't finish it? Great question. Well, if he takes the project with him and keeps working on it, and let's say, just for argument's sake, that he spent 2 weeks working on it while he was the property of the old master, and 2 weeks working on it while he was the property of the new master, and then it was finished, do we say that they split the value of that item? Or do we say, well, there was no item because it wasn't finished, it didn't actually exist, it had no value while it was being worked on, and it only sort of became an object that had value when it was completed, and that was under the authority of the second master, so maybe he gets all of it. I don't know. I don't know the answer to that question. Those would be the relevant issues, and perhaps we'll encounter such a case further on in our journey. Great question. Sharon, what if the slave died in the 30 days, not by the hand of the old or new owners? I mean, my instinct tells me, again, fantastic question. My instinct tells me that, when you purchase, I mean, anybody who owns a slave or purchases a slave has the risk that, the slave might have a heart attack at any moment, right? So I don't think that there's any guarantee that the slave is going to live for a certain number of years, because who can, offer such a guarantee? Maybe you could say, well, I'm going to give that guarantee just in order to entice somebody to make the sale. But let's say in the absence of that, I think maybe, the second master, even though he paid money, he's out of luck because he consented to the first master using this slave for 30 days. So it wasn't like the first master was stealing those 30 days worth of work from the slave that he sold. That was part of the deal. So I think if he dies during that period, the status quo, the money stays where it is. And I guess a good question, like a good mental exercise, I'm not going to do it now, but it'll be like, what would need to change in those facts so that the second master could, get the refund of the purchase price? If I'm right that he just bears the loss. So what would he have had to do in order not to bear the loss? Is he saying, okay, you can use him, but if anything happens to him, you bear the loss during those 30 days? Or maybe that was implicit anyway, and he could get a refund. I don't know. I don't know the answer offhand, but again, another great question. So that's what I've got for us today, and with God's help, tomorrow, Friday, noon Pacific, we'll open page